Oyez, oyez, oyez. The Honorable Court of Appeals for the Fourth Court of Appeals, District of Texas is now open pursuant to call.
You may be seated. Good morning and welcome to the Fourth Court of Appeals, or welcome back, I should say. The court is calling for 24-183 CV, all known, unknown, and known but unfound heirs, executors, administrators, successors, assigns, and personal representatives of Lewis and Eliza Eckford et al., Lou Etta Fourth, Stubbs Nixon, FRJK Legacy Family Limited Partnership et al. If I could get announcements from the parties, please.
Wayne Collins for the bills. Joshua Smith, I'll be arguing for the appellees.
All right. And how will you be splitting your time?
I'll be providing opening arguments, and to the extent that there is any time remaining, I'd like to cede the remainder of my time to Mr. Collins for rebuttal.
Okay, very well. Then, so of course, ordinarily we do 20 minutes, and 10, but I'll certainly respect that request. All right. And just for the parties, we have received the bench exhibits that were proffered by both sides. All right, you may proceed.
May it please the court. Good morning, everyone. My name is Stella Marks, and together with my colleagues Wayne Collins and Roy Elizondo, we represent the appellants who are the heirs of Lewis and Eliza Eckford. I think before we get started, it's important to note that today, to this very day, marks the 100-year anniversary of the death of Eliza Eckford. And I think that she would be turning in her grave to know that we were still disputing what she intended with regard to her land for her children. So the appellees are the heirs of Fritz Korth, so I respectfully ask that I be permitted to refer to them as the Korth heirs as opposed to appellants and appellees, just because I sometimes get my apps confused and I want the record to be clear, if that's all right.
Of course.
Thank you. The Eckfords have three objectives today. First, to provide you with procedural context on how we got here. Second, to discuss the many ways in which the trial court erred in first granting the court's J&OV motion, directing a verdict for the courts, and disregarding a sound and well-supported jury verdict. Our third objective is to provide argument as a basis for reversing the trial court's order and rendering judgment for the Eckfords, i.e., restoring the rightful jury verdict. As you know, this is the second appeal of a trespass to try title suit in which the courts sought to acquire an undivided one-half interest in land held by their co-tenants, the Eckford heirs. They first sought to recover under various legal theories, including the many adverse possession statutes, actual ouster, constructive ouster, presumption of deed, and other theories. The first appeal arose due to the trial court's improvident grant of summary judgment for the courts on the basis of constructive ouster and the limitations bar.
Ms. Marks, I'm going to go ahead and interrupt you.
Yes, ma'am.
I would really like to get to a very important question about this case.
Yes.
What is it that this court is supposed to do with the 1939 administrator's deed? Does it prove repudiation?
It does not prove repudiation at all. As the record reflects, the trial court found that that deed was a quitclaim deed. And as a result, there was no notice provided to anyone, especially the Eckfords, with regard to the land. They were not parties to the entry of that deed, and that in no way imputed notice, particularly given that the parties are co-tenants. And ouster is the standard that's required. The entry of Fritz Korth onto that tract in 1939 pursuant to that deed was a permissive entry, which as a matter of law cannot be considered adverse.
What do we do with the case of Republic Republican Production Company versus Lee, that says that that this could be an overt and notorious where there is no further evidence needed to prove notice to the Eckfords.
That case is inapplicable if you read it in the context of King Ranch, which further drills down on the responsibilities of ouster and showing ouster as between co-tenants. There is no evidence that the courts ever made a claim as to the property. There is no evidence that they ever provided notice to the Eckfords. And in fact, at trial, there was ample evidence provided that the courts, in fact, acknowledged ownership and the one half undivided interest of the Eckfords throughout the years, thus negating the notion of ouster or adverse possession. And as was discussed in the first appeal, the Thedford case and King Ranch case were distinguished from Republic because what is required in constructive ouster situations is an initial shot across the bow in which there is some notice provided remotely at some point in time, which can then be imputed forward. But that only counts if the parties were actually provided with notice. And there is no such notice. Fritz Korth entered
Real
permissibly.
quick,
Yes, sir.
Is notice required under Texas Civil Practice Remedies Code? This, I'm gonna call it 16.029, the Dominion statute.
That's an interesting question. And if you don't mind, Justice Spears, I'd like to back into that a different way. Notice is required vis-a-vis how to read 16.029. 16.029 is an evidentiary statute. It does not provide a claim in any way. And in particular, adverse possession statutes, as they are codified in Chapter 16, only pertain to strangers. However, the common law describes what is to happen in adverse possession cases, which with regard to co-tenants. So as a result, 16.029, which its title is, and I want to be precise here.
So you're saying it's an evidentiary standard. So in this case, it was decided in a JNOV,
Yes, sir.
which you have to bring forth evidence. And I guess you're saying it shifts a burden of persuasion, or does it make a rebuttable presumption of some kind?
It does. What this permits is, what it says is that parties who provide evidence that they've paid taxes for the requisite period and they have exercised dominion for the requisite period, along with the fact that the non-possessory co-tenant has not paid taxes and has not made a claim.
In this case, that was
The
found,
Eckfords, that was the Eckfords who did not. And as a
Up to
result,
that point, is there any dispute of the facts that you just described?
yes, there is. We would dispute the fact that they never met the prima facie case bar because they never made a claim. A claim is a requirement under 16.029.
Okay.
So in addition to those factors, there must be a claim made. And I
Okay,
think
so-
that,
So then real quick,
I'm
I have a
sorry.
question for you. So the first thing you said was 16.029 is not going to be applicable because we're not talking about strangers. We're talking about co-tenants, right? And then the second issue, there's others, I'm sure, but the second issue then is that the claim, that you're making the claim issue or raising the claim issue.
that's exactly right, because 16.029 as an evidentiary standard should be read together with 16.030, which requires a party claiming adverse possession to prove their case under the relevant statutes of the state. And this is indeed how the courts pled their case. When they added it to their pleadings just before trial, it was pled as 16.029 together with 16.030. So there was a clear understanding on their part that they were required to go through the process of adverse possession plus ouster.
Real quick, so that's, you're saying on the second element where it talks about a claim to the land. In your mind, what do you have to show to make a claim?
I think the best example of, or the best definition of what a claim is under the Osborne decision, in which a claim of right means that one must do something that brings to the attention of the non-possessory person that you are making a claim. You can't, there are several Texas cases that say you can't just adversely possess in your mind. You must bring to bear your intent.
Is it like a deed of some kind, or is occupying the land and fencing it enough?
It could be a judgment against the parties. It could be a certified notice. It could be the sale of land to a third party and registration of that deed. And
So
I
it has
think
to be some kind of color of title. Is what you're
it
saying.
doesn't require color of title. It just requires that you bring to bear to your co-tenant that you are taking their share. It's very different. It's a very much different
The
standard than.
1939 deed wouldn't be a claim, is what you're.
Absolutely not, because the 1939 deed, it didn't apply as to the Eckford heirs. It would not at all be a deed that would be considered under the circumstances. And in fact, that would demonstrate that Fritz Korth's entry into the land on 1939 was permissive. So upon Eliza's death, she was a co-tenant with her children. And then there was an administrator appointed for her estate, who was then the successor co-tenant and responsible for her estate. Subsequent to that, the land was sold to Fritz Korth, who then became co-tenants with the Eckford heirs. There is no indication that he ever gave notice to the Eckford heirs or indicated his intention to adversely possess as against them. And in fact, this was demonstrated again upon his death in the 1948 inventory, in which his two sons, who were the beneficiaries under his estate, specifically acknowledged the Eckford's ownership interest in the undivided 1/2. At that time, they stated, we only own 1/2, and the other half is owned by the Eckfords. This is a very powerful statement to make, given that these were the two people inheriting the land. This is not just an inventory, it's a statement against their own interest. They are saying, we own it with you together. And it bears note for another reason, one that wasn't raised at court, but one that was. Romeo Korth was a rancher, a banker. He was a sophisticated businessman. His brother, Fred Korth, at that time was the Assistant Secretary of the Navy and an attorney and a banker. These weren't people who just rolled into town. These were people who were accustomed to making complex decisions, entering into complex negotiations. They understood what was going on. And this is just because I'm a historian, and this is just interesting to me. When you evaluate the document, what's very interesting is it was written in 1948. That text is in bold. So for those of you who are much younger than I am, I had to learn how to type on a manual typewriter. And it's really hard because it was messy and it had ribbons and didn't have correction tape. In order to make something bold, it wasn't just a matter of highlighting it and hitting bold. You had to backspace and type over it again and type over it again. There was some intention, not just in stating that this interest was owned by the Eckfords. There was an intention in making sure that the document brought home to the reader that they only owned 1/2.
Can you tell us how the court got the JNOV wrong, in your opinion?
Yes, ma'am.
That was one of the points you wanted to do.
Thank you, Justice Meza. Well, first of all, let's see. Forgive me. There are several ways that they got the JNOV wrong. First, the JNOV was based on the court's assertion that the court's, I said court's assertion, not court's assertion. The court's assertion that the courts were entitled to a directed verdict, which is the same standard as a summary judgment, which is as a matter of law. But we know from Hardaway, this case could not be determined as a matter of law. At trial, the courts brought forth essentially the same evidence that they did in their first case, with the exception of testimony from their accountant, testimony from a couple of former ranch hands, testimony from a member of the Korth family, as well as a land expert who never visited the land. So in addition to the original testimony, which was the tax statements, the evidence of long continued possession, and the evidence of the absence of a claim by the Eckfords. So we know that there are many holes in the facts. So this case never should have been determined under a directed verdict standard because it's not as a matter of law. There are just too many fact issues outstanding. Second, the trial court disregarded the jury's answer to this specific issue. Third, the court misapplied 16029 in a number of ways. As we previously discussed, he treated it as a theory of recovery or a claim rather than as an evidentiary standard against which the rest should be judged. He ignored the legal principles of how to treat a prima facie case, which is if you meet the evidentiary bar to plead a prima facie case, then it's incumbent upon the other side to present evidence to overcome the presumption.
Yeah, that's what I was asking earlier. So the
Yes, sir.
Dominion statute would be the prima facie case, right?
That's correct, provided they meet the bar, but therein lies the rub, Justice Spears. The rub is they never made a prima facie case. They never made a claim. So as a result, they weren't even entitled to the presumption, but they got it anyway. In addition, I should mention too, not related to 16.02.
Are you saying there
sorry.
was no fact that was presented at trial where the jury could have reasonably inferred that?
There was not. And in fact, in the 2014 deposition testimony of one of the Korth descendants, she stated outright that they never made a claim. And even if they did make a claim, there was substantial evidence of, and I'm going to get this wrong, 6 instances of acknowledgement on the part of the courts with regard to the Eckford's interest in the title. As I was about to say, not specifically related to 16.029, they were also entitled at trial to the presumption that title had transferred as a result of their long continued possession. The jury chose to disregard that. And the way that that presumption works is the jury can consider it or disregard it. 16.029 was also misapplied, as I mentioned, because the court ignored the Eckford's substantial rebuttal evidence of the inference that title had passed. And the court also misconstrued what was to be rebutted. The court interpreted the rebuttal to be a rebuttal of payment of taxes as opposed to, a rebuttal of the presumption that taxes had been paid as opposed to the presumption that title had passed. You can't rebut a fact. You have to rebut the subsequent conclusion upon which the predicate facts are based. I hope I said that in a way that makes sense. I can restate it if I didn't. You can't rebut that we didn't pay the taxes. However, as co-tenants, in paying the taxes, the courts were behaving exactly as co-tenants should. And the final way in which 16.029 was misapplied, and perhaps this is the most important, and I realize I'm about to run out of time, so please forgive me, is that if we apply 16.029 in the fashion that it was applied in this case with regard to 2 known co-tenants, that flies in the face of hundreds of years of Texas case law, which says as among co-tenants, payment of taxes and doing other actions that are consistent with the co-tenancy are insufficient as a matter of law to demonstrate ouster.
But when you look at 16.029, particularly number 2, it's not just saying the taxes, right? That doesn't stand alone. It's a number of different factors. They
That's
openly
correct.
exercised dominion over, they asserted this claim and paid taxes.
Those are required, but we're asserting that they never made a claim, and there's no evidence in the record and no evidence that the courts ever specifically pointed to state this is what the claim was.
Quick, do you think you have to have ouster for 029? If they're co-tenants, I mean, is it different if it's a third party or a co-tenant?
Absolutely, yes, sir.
And that applies to 16029 as well.
It's the only way to make it consistent with the other rulings, the other common law in this case, which states that you cannot use evidence of payment of taxes as a way to oust a co-tenant. And it's inconsistent with the holding of this court in Hardaway, because the other two factors are long continued possession and non-assertion of a claim. And this court previously held that those are insufficient as a matter of law to prove ouster. 16029 must be read in conjunction with 16.030 in order to apply the law correctly, and that wasn't done in this case.
Ms. Marks, assuming that 16029 was satisfied at the trial level, how did you rebut that presumption that was raised?
We rebut the presumption that title had passed by our substantial evidence at trial of acknowledgement of multiple acts of acknowledgement of the Eckford's title throughout the years. The first, as we indicated, was Fritz Korth's peaceable entry onto the land in 1939. Subsequent to that, in 1948, the inventory prepared by the successors in interest, in which they asserted that they did not own this portion of the land. And the claim must be specific as to the Eckford portion. And that's indeed in the jury's instructions. In addition to that, throughout the life of Romeo Korth until his death in the 1980s, he never made a claim to the land. And in fact, in 2007, the Korth sisters, were notified that the Eckfords held a possessory interest in this land. And in a letter to them from Schooneman, I can't remember the name, from their landman, they were told, you need to speak to an attorney about this because they own this other half. The Korth sisters did nothing to assert a claim, and instead they entered into a lease 6 months later. The first time that the Korths made a claim was in 2012, and they didn't even start the claim. They tacked it on as intervening in a case that was filed by Burlington to find the unknown and unfound heirs. So they didn't even initiate it. I'm sorry, sir.
Prior to that, they had no knowledge they were co-tenants until the oil company told them.
We believe that they did based on the documentation in the
It's on the
record.
document.
Yes.
Okay.
And that was the majority of the evidence at trial for the defense was all of the documentary evidence.
I'm so sorry. Would you repeat
That was
that?
the bulk of your evidence at trial was those documents?
Yes, and these were all documents that were prepared by the Korth family. These were not documents that were manufactured by us.
Do you believe there was any conflict as to what the estate of Ms. Eckford owned at the time that she died?
Absolutely not.
She owned at the time that she died?
There was no conflict because at the time she died with a will, and the administrator of the estate had an inventory prepared. And in that 1925 inventory, it was made very clear that her estate had a 1/2 undivided interest in the subject tract, with the other half owned by the children of Louis and Eliza Eckford. So there was no mistaking that anyone had as to who owned what. And the
So how did the administrator's deed miss that?
It didn't, because the administrator's deed must be read together with the order for sale of the property, as well as the administrator's subsequent report.
Mhm.
And when you read those documents together, I think I stated that incorrectly. The administrator's deed must be read together with the order for sale and the administrator's final report. And when you read those three documents together, it is clear that the only thing that was conveyed was Eliza's undivided 1/2 interest. And if you look even further behind the documents, you'll see that in 1925, the administrator and the inventory that was prepared assessed a value to Eliza's portion of the estate. Well, 14 years later, when Fritz Korth purchased the land, he paid an amount that would be consistent with transfer of only 1/2 of the property. He did not buy the entire tract. And the administrator, knowing that there is only a 1/2 interest owned by the estate, had no power to convey more than he had control over. He could not convey the entire amount.
Real quick, I just have one more question. Is that okay?
Sure, of
I
course.
know we're over time. Okay, so the Dominion statute, let's say, for the sake of argument, that does not apply. How does adverse possession fit into this? It's kind of,
In a trespass to try title suit, adverse possession is the means in Texas by which one disseizes a co-tenant. And in fact, adverse possession ... ouster is the standard as among co-tenants. So you still must prove that. Under any circumstances,
is that the main difference is ouster? I'm just kind of looking at the adverse possession statute and the Dominion statute, and there's a lot of similarities, right?
there's a lot of similarities, there's a lot of overlap, but I like visual references. If you think of adverse possession and then it's ocean, and I'm going to get this completely wrong, ocean, your possession must be open, continuous, exclusive, adverse, and notorious. Ouster is adverse possession with a punch in the face. It means that you really must drive home to your co-tenant that you are intending to disseize them, because otherwise co-tenants would go along, and co-tenants have equal responsibility for maintaining the land as well as for enjoying the land. So unless it's brought to bear to the co-tenant that you intend to change the nature of your possession, you cannot just adversely possess against a co-tenant. And that's black letter, well, it's not black letter law, but it's certainly been the law of the state of Texas and the common law for at least 200 years.
Thank you, Ms. Marks.
Thank you so much.
Good morning, Your Honors, and may it please the court. I would like to frame my argument with response to two sets of questions that the court just asked. The first has to do with your questions, Justice Spears, about the relationship between the Dominion statute, ouster, and the notice rules. And then the second question, the second point goes to your question, Justice Meza, about whether there was in fact an ouster with respect to the events in 1939. And our position on both counts is that we win as a matter of law. Now, for clarity, we provided bench exhibits, and in tab A, we provided a timeline that can help to synthesize the timeframes with which I want to discuss these two theories. And this is important because the only piece of evidence that the Eckfords point to regarding the courts supposedly conceding that the Eckfords owned a share is this 1948 inventory. And as I'll get to later on, that 1948 inventory is irrelevant under the Dominion statute. It's irrelevant under adverse possession. But first, I want to dive into the text. At tab B, I've set forth a side-by-side of the Dominion statute and of the adverse possession statutes.
Mr. Smith, can you get to what acts proved repudiation?
Yes, assuming repudiation were required, the 1939 judicial decree ordered the sale of the whole parcel. It did not reserve a right in the Eckfords. It did not acknowledge a right in the Eckfords. That is on all fours with the Texas Supreme Court's ruling in King Ranch, where it said that a judicial decree adjudicating title to all of the land was itself a notorious act of ouster. And the point that I want to drive home is that when the probate judge has ousted someone, I've seen no cases that say that they can somehow be unousted. They haven't pointed to any. The judge ruled all of this is to be sold. And when the administrator proceeded to sell the land to Mr. Fritz Korth, he copied and pasted the judicial decree into the text of that order. Again, it conveys all. There's not a reservation. There's not an exception. And
It's a court order.
It's a court order. It's ouster by judicial decree.
And
But-
we assume that everybody had notice, I guess, since it's,
That's what King Ranch held. That's what this court held several years ago in the Gonzalez case, that you don't have to have actual notice when you have a judicial decree that is sufficiently notorious on its own for parties to be charged with constructive notice. Gonzalez was, as a matter of law, it was repeating the King Ranch rule. That's what we stand on with respect to ouster.
So could all mean whatever was in the estate of Miss Eckford?
The all said, I want to make sure I quote it correctly. In DX 123, and this is also in tab D of our bench exhibits. It says, it is therefore ordered, adjudged, and decreed by the court that said sale be, and the same is hereinafter in all respects approved and confirmed. And then at the bottom, all that certain tract or parcel. It's not all the tract that belongs to Miss Eckford. It's all that certain tract or parcel. And this court in the West 17th decision that we quoted in our briefs from a few years ago, there was a question of this deed. It conveyed all. And the question was, well, did that all include a co-tenant's 1/10? And this court held, yes, it did cover the co-tenant's 1/10. And even if it didn't cover the co-tenant's 1/10, it purported to cover it for purposes of adverse possession. And that's exactly what we have here. It's on all fours with the language that's in King Ranch.
What is your response to Ms. Mark's argument that it only granted a permissive entry onto the property as a co-tenant?
Your Honor, it does not say that. It says all that certain tract or parcel. That is the same language that King Ranch held was sufficient to oust the co-tenants by the court. The court
What kind
didn't.
of proceeding was that? Was
That-
that a foreclosure? Was that a partition? What was that?
That was a lawsuit. There was an assertion of adverse possession in that lawsuit back in the 1890s. And it was between two parties. And I'll note that the appellants have argued, oh, King Ranch is different because everyone who is an interested party was involved and had notice in that proceeding. The Texas Supreme Court in the King Ranch decision assumed for sake of argument that that was not the case. It said even if not all the necessary parties were involved, the judicial decree was itself still a sufficiently notorious act of ouster. This court addressed that same point in the Gonzalez decision regarding King Ranch. And this court said, developed an entire heading in Gonzalez. Part B of the Gonzalez decision is entitled Parties to the Lawsuit. And this court devoted an entire section, multiple pages of the Gonzalez case to explaining why the same argument that appellants make here was incorrect.
Are you saying that this deed is the 1939 administrator's deed is the deed that brought it home to the Eckfords?
The deed, but even more so the judicial decree. The Supreme Court has held that you have a constructive notice creates an irrebuttable presumption of actual notice. The fact that there is a judicial proceeding regarding the assets that are at issue, that's what provides notice to everyone else. You're charged with pursuing that. That's exactly what Gonzalez addressed, Justice Meza. That's what the Supreme Court held in King Ranch. But
real quick, they're saying the first time they got notice was when, I guess, the landman ran their chain of title. Did that chain include this judicial decree in it?
the judicial decree,
And I just didn't go, there was 200.
the judicial decree, according to their supposed chain, it does post-date that. But that was the exact issue that was before the court in the Lee case that you talked about, Justice Meza. There was the partition proceeding happened outside of the chain of title. But most importantly, there are no cases holding that you are excused from notice of a judicial decree regarding the land itself. That was King Ranch, that's Gonzalez, that's this case. But if,
Can we move on to the other point about the jury, the court overriding the jury verdict?
Yes, Your Honor.
16.029. Can you address that, please?
yes, Your Honor, the key point there is that ouster is not even required under 16.029. And because this is a statute that's not been adjudicated very often, I think the answer to your question has several steps. And so if I may, I'd like to start with the text of the statute, and then I'd like to move to our prima facie case, and then I'd like to address the supposed acts of rebuttal. So starting with the text of the statute, in tab B, we have set forth side by side the Dominion statute versus the adverse possession statutes. And the key point that I'd like to make is that ouster is not required under 16.029. The Fifth Circuit held in the Humphreys case, this is separate and independent of adverse possession. And there are several textual steps to this analysis. If I could point the court first to the different purpose of .029 and adverse possession. The very start of the bench exhibit, it is prima facie evidence that the title to the property has passed. The purpose of Dominion is to create evidence that there was a missing conveyance, that title indeed passed. You don't have to oust someone who has already transferred title to the property. You don't have to oust someone who has already sold the property, transferred title to the property. Completely different from adverse possession, Your Honor, where the purpose is accrual and bringing suit after accrual. And this ties next to your question to the appellants, Justice Spears, about is there a notice element in the Dominion statute? There is not. I point the court to the Wiggins case that we have quoted and cited in our brief. And the Court of Appeals in Wiggins said, we think that Article 5519A, that's the old predecessor to .029, requires Dominion not to convey notice of the claim evidenced by that Dominion, but instead, because it is a circumstance strongly tending to prove that the title claimed was really owned by the one who claimed that title. Again, the purpose, you don't have to oust someone who has already transferred the title. And you can see the difference in Dominion. It requires a claim to the land. Adverse possession requires a claim that is, quote, hostile to the claim of another person. Adverse possession looks at the other person. The legislature knew how to state that if they had wanted to. They didn't in 16.029. That distinction, Your Honor, should be honored. And I'd like to point the court just as a principle of statutory construction to the court's decision last year in Harbor America Central. This is 692 Southwest 3rd 777. The Supreme Court actually denied the petition for review that was filed in that case 5 days before Christmas in 2024. But this court stated, when the legislature uses certain language in one part of the statute and different language in another, the court assumes different meanings were intended. The Dominion statute intentionally does not use the claim of another person language. It says a claim to the land. It's not focused on ouster. It's focused on evidence that, oh, is the transferor acting as if the transferor has parted with title? Is the transferee acting as if the transferee has received title? And when you prove that prima facie case, you don't have to oust the person where there's evidence that they already transferred the title.
And that's by the decree, right?
That's by the
Claim.
the ouster, the claim to the land, that's by the deed, that is by the decree. That is by the locked gates where the combinations were not provided to anyone else. That is by paying taxes not on half of the land, but on 100% of the land. If the court looks at tab C, the court will see the Eckford stipulation that they have never tried to enter the property, they've never paid taxes on the property, they've never done anything that someone who owns property under 16.029A1 that the transferor would normally do. And that has been stipulated to. They haven't behaved as the owner. Justice Spears.
Yeah, real quick on the prima facie case, you're saying once that's shown, what happens after that? Is it like a no evidence MSJ type of situation? Do you have to bring forth something, a scintilla of evidence?
Correct, Your Honor. It's their burden to present something rebutting the presumption that title has passed. And they have shown nothing within the requisite window that would rebut a presumption that title has passed.
Isn't their position they own it by inheritance?
I'm sorry, Your Honor?
Isn't their position that they own it by inheritance?
That's their position, but that doesn't change that they haven't behaved as an owner of a property would. More specifically, it doesn't change the plain text of .029A1 that you have to be, that they have failed to pay taxes, they've failed to exercise dominion. It's not hard. It's not hard for a co-tenant to prevent this statute from operating. Just pay your share of the taxes. Just take an excursion on the property here or there. They've stipulated that they never did so because they didn't think that they owned it for all those years.
So despite the stipulation, a few minutes ago, you made the comment that the 1948 inventory is irrelevant. So let's
Correct.
talk a little bit about that.
Yes,
because
Your Honor.
Clearly, the courts thought that a portion of this land did belong to the Eckfords in 1948.
Right. I want to divide this into two time periods. And that we have far more than 25 years after 1948 in which we satisfied the Dominion statute. So even if, for sake of argument, the Eckfords owned their share in 1948,
By the court's acknowledgement.
but by the statement in the inventory, yes, Your Honor.
Yes.
We have half a century following that, giving rise to the presumption, the prima facie case, that sometime in the following years, there was a conveyance by the Eckfords to the courts. The mere fact that someone else owned the property in the past, or even that one side acknowledged that the other side owned the property in the past, doesn't prevent Dominion from operating. Indeed, that's the very basis of needing to have Dominion. It's that someone else once owned it. So let's see what has happened in the time thereafter. And so if the mere fact that the Eckfords once owned the land were sufficient to prevent Dominion from operating, then you could never use the Dominion statute. It'd be a waste of ink because it's true that someone else, there would have always been a prior owner. The point is that it's transferred from A to B. And in the many years after 1948, we have established every element of the Dominion statute as a matter of law. So past acknowledgements can't undo the future adverse possession or the future Dominion. Separately, if we look at adverse possession starting straight in 1939, that is between that period and the time of the 1948 inventory, is over 5 years. We have no statements by Fritz Korth, the one who actually entered on the property, owned it, cultivated it, paid taxes on it during that period, acknowledging title and anyone else. Instead, we have a judicial decree adjudicating that there should be a sale of all that certain tractor parcel to him. We've established adverse possession by Mr. Korth prior to those statements by his sons, not by him. And if the court looks back at tab A, we've quoted the Stetson case from the Texas Supreme Court that says future acknowledgments cannot undo a limitations title that is already vested. And in our brief, we pointed the court to the Scribner case out of Fort Worth, where on summary judgment, the Fort Worth Court of Appeals said, there's been ouster as a matter of law, even though some subsequent parties weren't as sure about the fact that there had been ouster because it was satisfied by the original holder during the relevant time period. You can't undo the adverse possession after the fact. The statements by Fred and by Romeo in 1948 don't undo the adverse possession beforehand. It would create a split of authority with the Scribner decision to hold that they could somehow undo Mr. Fritz Korth's adverse possession during that period of time.
I did have a question about the common law adverse possession. What was the evidence that conclusively proved that the Eckfords acquiesced to the presumed grant?
That's the same evidence of them standing there for decades and decades without taking any action on the property. I'd point the court to the Ray v. Baker decision, 1931. It was a writ refused decision, meaning that the Texas Supreme Court adopted the Court of Appeals decision as its own, said long continued possession by one, non-use by the other. That shows that they had noticed that it was brought home to them and they never stepped in. But especially on dominion and on adverse possession, we've proven the two as a matter of law. We ask this court to affirm, and there are two questions that appellants have yet to answer that I think this court deserves an answer to regarding both dominion and adverse possession, and that is if dominion requires ouster, then why did the legislature leave out the words claim of another? Why did it leave that out in the dominion statute? That difference means something. And second, can they point to any cases where once a judicial decree has ousted a party, that judicial ouster can somehow be undone? I'm not aware of any such cases. This court should
Are you talking
affirm.
about where it says hostile to the claim of another person in the adverse possession?
Yes, Your Honor.
Hey, real quick on the directed verdict during the halftime. So it was denied, but then later the judge said that had he known that the gap in paying taxes was okay, he would have granted it.
Yeah, he had questions about how the facts worked for proving the prima facie case. And we more thoroughly briefed those in the JNOV motion and in the supplements to the JNOV motion. I don't understand that to be in dispute at this time by the other side. It's important because I don't know what my friend on the other side is gonna say in rebuttal. And if I may just get out ahead of it real quick, Justice Meza, your opinion 8 days ago in the In Re MNR decision said that the mere fact that you might reference some argument in the issues presented isn't enough to preserve it if it's not developed in the body of the brief. And I'm not sure if there's going to be new angles, but we believe that this is the universe of the issues that we're addressing in this appeal. Thank you, Your Honors.
Justices, I know we stated that Mr. Collins would provide rebuttal, but if I may, be permitted to substitute again, I would very much appreciate it.
Of course.
Thank you so much.
May it please the court. First, I want to begin by clarifying what the King Ranch decision means in the context of the 1939 Administrator's Deed. King Ranch involved a judicial decree that dated back from the 19th century, as well as another litigated matter that brought home to the person against whom, I'm stating it incorrectly, there was notice brought home because there was an actual controversy, and the predecessors in interest were made aware of the controversy by the person making adverse possession. The adverse possession statutes and the ouster statutes speak to the conduct of the actual adverse possessor. One cannot piggyback on a judicial decree in which the person against whom is being adversely possessed has no involvement. You can't impute knowledge to someone if they weren't a party to the action. King Ranch would have been applicable if, in fact, Fritz Korth had provided notice to the Eckford heirs that he was repudiating the co-tenancy. If there was something else that Fritz Korth did to bring home to the Eckford heirs that he was taking this action. And there is nothing in the evidence, there's nothing in the record that demonstrates that. I think it's also important to note that in the documentation, as I stated before, you cannot read the administrator's deed in a vacuum or in little chunks. The entire document must be read as a whole in the context of what has taken place in the probate courts. The administrator's deed could not possibly have granted the entire tract to Fritz Korth because, as the order states, and as the administrator's report states, together with the administrator's deed, the only thing that was conveyed was Eliza's interest. Fritz Korth knew that, the court knew that, the administrator knew that. So how the Korth successors and interests didn't know that is beyond us. We don't understand how there could be any lack of clarity around that.
Ms. Marks, in the event the trial court got the granting of the J and OV wrong, the other side has cross points on appeal that this court has to take on. How do you overcome those cross points?
They didn't provide sufficient evidence for the jury to find in their favor. I mean, I don't know how to state it more simply than that. There wasn't evidence in the record to overcome those points. I guess as a final point that I would really ask that the court consider is the interplay between 16.029 and the common law with regard to ouster. If we decide that 16.029 is a cause of action, as I stated before, that flies in the face of all common law. That means that all of those cases, the parties could have simply pled 16.029, provided the parties were co-tenants, and they would have immediately won. 16.029 has been around for a while. It was amended in 1985, and it is the successor legislation from 5519A, which was passed in 1939. So this has been here for a very long time, yet nonetheless, since that time, there have been a number of cases involving co-tenants in which ouster was the standard that was applied. It's also important to read 16.29 using its title. It's an evidentiary standard. It is not a claim of right. And Section B of 16.029 states, this section does not affect a statute of limitations, a right to prove title by circumstantial evidence under the case law of this state, or a suit between a trustee and a beneficiary of the trust. The dependent clause doesn't matter. So it means that the party still must go through the steps in order to prove adverse possession. And in this case, it's the higher bar. It's ouster. There's been no question that the parties are co-tenants. And in fact, that's how all the pleadings have read.
What do you, the appellee brought up the fact of when we're looking at legislative intent, dominion, it's talking about someone who's been there 25 years. It's the parent record title, and then adverse, it's hostile to the claim of another, like a third party. Explain that to me, the intent.
The predecessor to 16.029 and is 5519 and 5519A. And those statutes were intended to help people who were somehow disadvantaged in not being able to get to the court. And again, these are between strangers. This wanted to reward people who have been living there for a long period of time, who've been tending the land, who have been paying the taxes, and they've lived there for a long time, but they just couldn't get to the courts in order to register those deeds, and they wanted to give them a mechanism for claiming title. Those facts don't apply in this case. Fritz Korth certainly had an opportunity to perfect title. If there was any lack of clarity in 1948, his successors certainly could have gone back to the court and said, we need to perfect title. There's a mistake here. But they didn't. They owned the fact that they did not own the undivided 1/2 interest. There was no ambiguity at all.
So you're saying this deed, the notice to the world when you're publicly, filing these documents, it somehow didn't trickle down to the heirs? Like it shouldn't be applied to the heirs, because what? Why? Why would that not be noticed an act of repudiation to the heirs? And I'm mindful that at that time, the heirs were children, some adults, some not adults. So how is the filing, the sale, those 3 documents you want us to look at together, how is that not an act of repudiation to the Eckford heirs?
Because it's not noticed to them that the courts are making a specific claim to their undivided 1/2 interest. The Korth family, or Fritz Korth, is only making a claim as to the undivided 1/2 interest owned by Eliza. And there's no way to read the document as making a claim on the other undivided 1/2 interest because the deed wasn't recorded with regard to that portion of the land.
So you're saying even if the children had, or some were children, but even if the heirs had seen this deed and read the all language, there would have been that assumption, this was not sufficient notice to their half, only to their mother's half, essentially.
That is correct. And you can't just read the all description outside the context of with regard to the property in Eliza's estate. Those things can be read together to harmonize them. All refers to the entire property description, but that fraction interest is what speaks to what Fritz Korth purchased. I'm not saying that, I'm sorry, Justice Valenzuela.
So you're saying even if they participated, the deed on its face doesn't give title to anybody else other than that 1/2 interest?
That is what I'm saying. Yes.
Right.
Thank you so much.
All right, thank you. Both sides, thank you for your arguments. This case will be submitted and we are adjourned.
All rise.